As an estate planning attorney, one of the questions I get most often are which documents are most important in doing an estate plan. Hi, my name is Bill Miller, and I'm an estate and elder law attorney with offices in Anniston and Birmingham, Alabama. When people think about estate planning, most people are only concerned about what happens to their assets when they pass away. Who gets their house, who's going to get their accounts, and things like that. And so often they'll come into my office and their main concern is getting their will drawn up or getting a trust or some way to dispose of their assets whenever they pass away. But now that people are living regularly into their 80s and 90s, and we're seeing more and more people who become incapacitated through Alzheimer's or dementia or incompetent due to other reasons, it's really important that you plan for disability as well as for what happens whenever you pass away. So the three documents that everyone needs in order to address both what happens if I become disabled or incapacitated or incompetent, and then what happens when I pass away are, number one, you need to have a financial power of attorney. Number two, you need to have an advance directive for health care. And number three, you need to have a will or a trust or some way to dispose of your assets whenever you pass away. So let's first talk about the financial power of attorney. That's a document that you sign that gives someone else the authority to handle your business, to do any kind of financial transaction that you might do if you're not able to do so any longer because of incompetency or incapacity. So it gives them the authority to do anything you can think of, really, such as cash your checks, pay your bills, sell your property, access your retirement accounts if necessary. Anything that you would need to be able to do financially, you want them to be able to do by giving them the power of attorney. The second document you need is an advance directive for health care. So that is really a two-part document that deals with health care issues. The first part is a living will, and the second part is a medical power of attorney. So in the living will, you would put your wishes in writing about whether you would or would not want to be on a respirator or receive treatments or be on a feeding tube if two doctors determined that you were terminally ill or injured to the point where without these treatments you would die in the near future. In other words, that these machines are really only keeping you alive, they're not going to cure you. Or if you become permanently unconscious, again, would you want to be on breathing machines and feeding tubes and things like that? So you put your wishes in writing in answer to those questions, and that way your family knows what your wishes are if that time ever comes. Just as importantly, but we don't see it as often, is part two of that document, which is a medical power of attorney. And the purpose of a medical power of attorney is, let's say that you're not on your deathbed, so your living will really doesn't apply, but you need to have some type of a medical procedure done, and you've got Alzheimer's or some other form of dementia, and you're not able to make decisions for yourself. Well, if you can't make decisions, then who's going to decide whether you have this medical procedure done or not? So you name a medical power of attorney to do that. And so if you ever get to that point and you need a medical procedure, then they're authorized to make that decision for you. And it's also important to include in that medical power of attorney a HIPAA authorization, because under the HIPAA laws, which are medical privacy laws, if you don't authorize the doctors and hospitals to speak with your medical power of attorney, then chances are they're not going to do so, and they're not going to be able to make decisions on your behalf. So it's really important that you have both parts, the living will and the medical power of attorney. Now, the first two documents I talked about, the financial power of attorney and the advance directive for health care, the second you pass away, they're no longer valid. Those documents are just there to authorize someone else to make decisions for you financially or for health care while you're alive, but once you pass away, they're no longer valid. The third document that you need is a last will and testament. And most people have heard of wills, but a will basically says whenever I pass away, then here's who I want to get the assets that are in my name. Now please remember that some of your assets may not pass through your will. If you've got beneficiary designated accounts like IRAs and life insurance and things like that, then those assets are going to pass directly to the beneficiary that are named on the accounts. But the will is designed to pass title to any assets that are just in your name when you pass away, and that happens through the probate process. If you don't have a will, then it's a real burden on your family if they have to go through probate, because they have to do an estate administration which is time consuming. It requires more expense, more hearings, and things like that. So again, the 3 documents that everyone needs are a durable financial power of attorney, an advance directive for health care, and a last will and testament. If we can help you with any of these, please give us a call at 256-241-6794. We'll be happy to help you.